Okay, first, let's introduce the zoning board of appeals members. I am Douglas Cummins, I am the chair. This is Liam Anea, he is the vice chair. We have Richard Briggs, who is the secretary. We have, to my left, Elijah Hewling III. Then we have Terrence Petropin. We have our two alternates, Michael Barnes and, why am I blanking on names right now? Larry Rushmeyer. Sorry, my bad. It's been a long day. So first order of business, we need to approve the minutes from our June 1st meeting. I will entertain a motion.
So moved.
Need a second?
Second.
Let's have some, any discussion? Was that all your water? All right, any discussion? All in favor of approving minutes as they are written, say aye.
Aye.
All opposed? Any abstentions? Motion passes. Any correspondence, Mr. Secretary, that we need to address before?
Let's see, no correspondence.
Here's the application.
Yeah, outside of the application or the meeting that we're gonna.
Do it as the application comes up?
Yeah, that's fine. All right, moving on. All right, for continued hearings, we have ZBA 26-818 West Wisconsin Road. May I have the, let me do it. Homeowner. All right, so before we get started with that, since this is a appeal of the zoning board, we haven't had this meeting it's been continued for a while, so we kind of have to reiterate our position here. Yeah, got it. Okay, go for it.
So, in the case of an appeal to ZEO, the zoning board must hold a public hearing and hold the case de novo, which means anew without prejudice. We must give fair consideration to both the applicant and the ZEO without favoritism. We must consider all the facts and evidence submitted and use best judgment when rendering decisions. We may uphold or reverse in whole or part the decision of the ZEO. 4 votes are required to reverse in whole or in part this decision.
All right, so this is a regular meeting of the Board of Zoning Appeals. At this point on our agenda, we have scheduled a public hearing concerning the application of 18 Wisconsin Road, John O'Hare. We will open this public hearing by calling upon the Commission's Secretary to read the legal notice of hearing.
So, let's see. Read this, these published the following legal notices on May 19th and May 21st, 2026. So this notice to you.
Mr. Chairman, I think the notice is from the June meeting.
Oh.
That might not be.
Okay, that's fine.
I think it's just.
Yeah, all right, so, all right, so have the applicant come forward and let's do your case.
Good evening. I have some materials for the board. I'll hand those out.
You just have to state your name.
Name, address, and
I have trouble walking and talking at the same time, so.
What about chewing gum?
Yeah, guys, you heard that? What's it called?
thank you.
Okay. Good evening, my name is Peter Olson. I'm an attorney in an office in Bethel at 275 Greenwood Avenue. My firm name is Land Use and Conservation Counsel. I'm here tonight on behalf of the homeowner, John O'Hara, who's sitting right here. He owns the property at 18 West Wisconsin Road and is a longtime resident since 2000? 1994. So he's been living here quite a long time. This is an appeal of a cease and desist order issued by the zoning enforcement officer of the town of Brookfield dated April 14th, 2026. And it alleges a violation of zoning regulations Article 6.10A6. I handed out a copy of that in the black and white package, first page. The provision is in question is the second half of section 6. It says, fences shall not be placed in such a manner as to inhibit lines of sight or otherwise affect traffic safety. The first color picture that I provided to you is a photograph of the fence as it stood around the time of the cease and desist, probably a little bit after. So you can see exactly the fence that we're talking about. It's set on top of a small stone wall on the property line adjacent to a neighboring common driveway and West Wisconsin Road. We timely appealed the cease and desist order to this board, and we had a public hearing scheduled. We postponed it a couple times to try and get some more information about what law applied and how to specifically apply it. So for the first hearing, we did send notice to abutting property owners, and I have the green cards to submit to the record. I'm glad I could find those. It's been a couple months. As Mr. Ney, as you read, appeals from decisions of the zoning enforcement officer to this, they come to this board for consideration. Your review and decision is de novo. That means there's no deference given to the CEO. He didn't make a special decision that you have to abide by unless he's wrong. It's essentially your job to review the evidence and make an independent decision as to whether you think the zoning regulations have been violated. So the purpose of the hearing tonight is that we are going to ask you to reverse the CEO's decision and vacate the cease and desist order. As I go through here, I realized in my notes I referred to the action I want you to take in various points as vacating the order, reversing the order, quashing the order. They all mean the same thing. And we have the same vote, 4 votes as required. The first thing I would like to note for the board is that after we received the cease and desist order and my client spoke with me, my advice to him is remove the fence that is alleged to be non-compliant so that while we work our way through this process, we are in compliance with their zoning regulations, which we have done. And if you look at the second color photograph, I believe, you can see a picture of the fence as it is in its current, or it's not the second one. Well, sorry, it's not in the package. You just have to trust that we did it. The other pictures here that
We have pictures,
will
yeah.
show you. Yeah, I'm sure you've got plenty of pictures that show it. But it is currently in compliance with the zoning regulations. However, we have maintained this fence, as I will go into detail, for almost 25 years, and we would like to put it back as it's been maintained for 25 years. So that's why we are continuing to push forward with this. We hope you will agree with us that the order was issued in error and that the fence can be returned to its location. But currently, the property is not in violation of the zoning regulations. So, our first argument, if you look at the cease and desist order, which is page 35 of your packet tonight, our position is that the cease and desist order on its face is invalid and therefore defective. It is addressed to John O'Hara, 18 West Wisconsin Road, and identifies the zoning violation that we're talking about. However, it identifies the property that it's in violation as 40 Hidden Brook Drive as the violation. Given the potential for the financial penalties that are associated with zoning violations, daily fines, attorney's fees, as well as the possibility for criminal penalties for zoning violations, it is important that these things are done correctly. So right at the bat, the cease and desist order is invalid and defective, and you should throw it out, vacate it, quash it, right on that ground alone before we even get to the merits. Now, you're not so lucky. I've got several pages about the merits, because I think we do need to consider them. On the substance. Better to resolve this on the substance rather than simply the procedural question, which then comes back to you when it's done correctly. First, the fence was replaced recently. The photograph, that's the first photograph there, is the fence in its new configuration. Replacement of the wood, basically. But it stood in that same location as a fence which had existed for nearly 25 years. My client got a driveway permit in 2001, and then a year after that, put up a fence. And there was kind of a rubble stone wall that existed that's been replaced with a nice, neat stone wall. So the second image I'm showing you in the image package is the Google Maps image, which is dated November 2022. So that's 4 years ago from where we are today, and 3.5 years prior to the cease and desist. And that's the fence as it was, according to Google Street View. I only brought one copy of this, but this is the Yukon Clear image database for the state of Connecticut, which they maintain satellite photographs that are taken every couple of years. This one is from 2004 in the springtime and is at the 1 foot resolution. So I'll hand this in for the record because I'm just trying to demonstrate that the fence has existed. I labeled 18, that's the driveway to my client's property, and I circled the fence that you can see the shadow of the sun makes part of it really visible, but the rest of it is visible. So I'll hand this in if you want to pass that around. So the fence has existed 25 years. I'll be rough. We couldn't tell you the exact date, but it's at least since 2002. At least since 2002 when we put it in, and it's visible on that satellite. So why do we care that it's been in place for 25 years? General Statutes 8-13A applies, and that is the second page of the black and white package that I handed you. It provides that structures that violate the zoning regulations in relation to boundaries of the lot and have existed for 3 years become non-conforming structures that are permitted. They are considered to be non-conforming, much like you would have where somebody would ask you for a variance for something that's a non-conformity. And therefore they can remain even though they're not in compliance with the regulations. They're essentially deemed to be in conforming because they've been there for 3 years. You may say to yourself, why do we have this statute? Well, the point is to make ZEOs do their job, right? If somebody builds a house and it's too close to the setback, the ZEO is supposed to go out and inspect and issue cease and desist orders. And why is it important for us? Non-conforming structures can be replaced in their existing location, whether they violate the regs as they stand now. As long as you do it in the same location, you're fine. You can't move it and make it worse, but fine. So, sightline regulations, given that they're calculated in general with respect to the boundary line as it relates to the road and any driveways, those are boundary lines, are zoning regulations that relate to the boundaries of the lot. And therefore, they are within the ambit of 8-13A. So the effect of this, in our opinion, is that when we replaced the fence, we were allowed to replace it in the location that it's been for 25 years, and it doesn't have to comply with the provisions of 6.10.A.6. So for that reason, as a legal matter, the cease and desist order should not have been issued, and you should vacate, quash, reverse, whatever we want to call it. To the regulation itself, what do the regulations mean by sightlines when it says you shall not obstruct the sightlines? And the answer is, we don't know. We have no idea. There's no provision of the regulations that says how you in the town of Brookfield are supposed to determine what a sightline is or should be, how to calculate it, what the rules are for the calculation, and I'm going to get into some detail on that. There's no town road ordinance that we could point to. There's nothing that tells you, the town of Brookfield, how you should interpret the word sightline. There is something in the subdivision regulations that has certain sightline requirements that you have to meet based on the speed of the road. But they don't tell you how to calculate it. They don't give you the guidance that says, here's what we mean when we say sightline. And by the way, this isn't a subdivision application, so they don't apply anyway, but I'm trying to cast a wide net to find some authority for how to interpret this. So I would argue that at the outset, this regulation itself is unconstitutionally vague. It doesn't tell anybody what the rules are that they have to follow in order to meet the regulation. And therefore, it can't be enforced. This is particularly important, again, I mentioned this before, when you have civil financial penalties for not complying and you have criminal penalties for not complying with zoning regulations. So how do we figure out if we're going to try to apply the regulation, how do we figure out what it means? It's possible that this could be done by reference to outside sources. Different jurisdictions, different governments, and what they consider for sightlines, how they calculate sightlines. One such source, which I'm sure you've seen in your package, and was prior part of the zoning regulations, not for this purpose, but is referenced elsewhere in the regulations. One such source is the Connecticut Highway Design Manual. This is a manual that's published by Connecticut Department of Transportation that tells us how we design highways that are state highways. And I provided a copy of the relevant section, which covers intersections, section 11 of the manual. And in particular, section 11-2 sub 1 is the language which I'm sure we're going to talk a lot about tonight. So maybe I should mention 11-2.3 talks about the height of the eye first. So we start at 3.5 feet high. That's because a driver sitting in a car is where you're supposed to measure a sight line from. So 3.5 feet high. It's not really important for anything we're doing tonight. But. So what this says is that when you have a minor road intersecting with a major road, that you measure the sight line 15 feet from the traveled way. And you're supposed to do that from the center of the minor road, which is where you would sit if you were a driver, in the right-hand lane getting ready to pull out, right? That's where you stop. And you'd think that would be easy. Like this is easy. We draw a line, we draw a point, and we say this is where you measure the sight line from. Okay. But the Highway Design Manual only applies to state highways, like Route 25, 202, and roads that intersect with those state highways. Those intersections are things that the Department of Transportation has jurisdiction over and are going to review any application for roads and driveways on those things. Doesn't apply, the Highway Design Manual, to roads like West Wisconsin, which is not a state highway. It's just a town road. And so the Highway Design Manual, even though we have this nice definition of a sight line up front, says later on that it is not the controlling criteria for projects. This is subsection G of 4. It's the third page I provided you. ISD is not a controlling criterion for projects designed by municipalities for roadways owned and maintained by the municipality, local road projects. So why is this a big deal? Well, whenever you have a minor road intersecting with a major road, that's a state highway, you're going to have stop sign or a traffic light, you're going to have a stop bar. This is where people are expected to stop, not that anybody ever does, but this is where they're expected to stop before they enter that state highway. Because we don't have that here, these requirements are overkill. They are far more than is required for this type of intersection. So despite what may look to be an easy way to resolve what a sightline is, it's not. The 15-foot statement is, we believe, not a hard and fast rule. You being the decision maker in this case, although normally it would be the CEO or the town engineer or highway department, can apply a reasonable standard when it's trying to figure out what an appropriate sightline is. You're not subject to the Highway Design Manual.
For sake of expediency and just to kind of understand what we're looking for, what are your exact ask. The fence is a non-conforming use, has been repaired or hasn't been extended beyond its footprint. And what your belief is that the cease and desist was given in error, and now the objective of this hearing is to either uphold, reverse with possible stipulations.
We would like you to reverse the cease and desist order, whatever form that is. Say it was incorrectly issued. That will allow us to reestablish the fence in the location it was in before we removed it after we got the cease and
Okay,
desist
so
order.
essentially, like as it is, that corner of the fence is, that little piece, that little triangle was been
Exactly.
is what's missing. You essentially just wanted to go back to be able to have that little
Exactly.
triangle.
If you look at this photograph here, what you can see is the wall that we built, the fence goes along there and then along the front. And instead it stops here. That's what we're looking for. But I'm trying to lay the legal groundwork for what will be comments from neighbors who have submitted materials to you arguing that it should be something different. So unfortunately, I do have to continue. But you've cut to the chase, you know exactly what I'm asking for. So as I said, this is the standard for intersections of major roads and minor roads. On top of that, what is called Norris Lane has a name, but it is not a road. It is not a minor road. It is a driveway. It is a common driveway. It serves 6 houses. It is privately owned. There are easements for the use of the private road. It is not a town road. It's just a driveway. So none of these requirements really apply. So let's say nevertheless that the Highway Design Manual is a useful reference, right? I could see that. We had a surveyor go out and put a stake in the ground, well, a pin in the ground on Norris Lane where you would measure. I say where you'd measure, but I'm going to contradict myself in a minute. On Norris Lane, and then put a stake in the ground that shows looking down to the left where that stake would be. And there's a photo that I know the neighbor submitted at page 87 of your packet that shows exactly where this stake would be, and it is in the middle of this first segment of the wall. You can see this, if you look at this first picture, you can see the rock, and it's on the left side of the rock, about where the vertical piece comes down. That's where that stake is. So we set that based on a measurement that was 15 feet back from the edge of the pavement of West Wisconneer Road, because we felt that was the most conservative estimate of what that would be, and we wanted to look and see what it looked like. However, if you look at this third page that I gave you, this is a Google Street View of West Wisconneer Road. And what you can see is that the edge of the pavement, where it meets the driveway, it's obviously a little fall off to where it's less well maintained, but it curves inward as an apron for the driveway by at least a foot and up to 18 inches. And you can see that even more on the next page, which is a photograph that we took. What you can see is that if you drew a straight line, curb to curb across the front of the driveway, there's still additional pavement 12 to 18 inches back.
You're looking at that?
I'm looking at that.
Okay.
So it kind of, the road goes like this and then in. Why am I doing that? Well, in the Highway Design Manual, it says you measure from the travelway. So our 15 feet to get to the stake was measured from the edge of the pavement, but we think the travelway is actually about 18 inches closer to the center line of the road. So that's number one. Number two, again looking back at the third page, which is the Google Street View, this one, you can see that there are catch basins and drainage in West Wisconneer Road. And generally, people don't drive over the catch basins. They're going to drive to the left of the catch basins, between the center line and the catch basin. So we don't think the catch basins should count as part of the travelway either, which is another 2 feet. So, these are minute things we're talking about. But if that stake were moved 36 inches, for example, closer to the road, our fence goes right back up where we had it in the first place. So even if you apply the highway design manual, if you say the travel way runs, from the edge of the catch basins to the center lane, we'll measure 15 feet from that, and we can show you that the fence fully complied with even the highway design manual. So because sightlines are like a triangle, you have one leg that's 15 feet, and one leg that's 300 feet or whatever, and then the angle, it's not quite the same measurement, but it's pretty close. Okay, and then finally, and this is not a minimal point, if you're in a car and you're getting ready to exit the driveway, you're not stopping 15 feet back from the edge of the road, ever. You're going to pull up to the edge of the pavement, and then you're going to look. So that's not 15 feet from the road, that's 5 feet from the road. No stop sign, no stop bar there. Just going to pull up. Maybe a person will stop, not all the time. They'll look, there's no problem. There's nothing obstructing the view. Even a really big car is going to be able to see down the road. So what I'm arguing for is for you to take a reasonable interpretation of what the word sightline means and make the determination that the fence, as it was located, did not violate the zoning regulations. And if you can make that conclusion, then the cease and desist should be vacated, and we should be permitted to put the fence back up in the location it was in.
So what's the quarrel with the fence as it stands currently with the triangle, cut out? What's the problem? What's the?
I don't want to speak for our neighbors. I understand that materials have been submitted. My guess is they believe that it obstructs the sight line. So my argument to you tonight is not only does it not obstruct the sight line, but any reasonable interpretation of what the word sight line means does not have the fence as an obstruction looking to the left.
But just for the sake of your client, sorry, the fence is as it stands right now with that triangle not there. Why? What would be the issue to leaving it that way?
It looks stupid.
Aesthetics?
Aesthetics.
Okay.
The intention of this is to provide screening for my client's house, so there needs to be a fence there. There's headlights that come in from across the street that shine directly into his house. That's why he needs a fence.
No, the fence is fine. I'm referring to this triangle that's cut off.
Right, so what would happen would be you would have a fence and then a small patch of grass and then a stone wall that looks really nice.
Mm.
And that's a very difficult thing to maintain without letting it get overgrown.
Okay.
I have a question. This picture that was submitted, is this what it looks like currently?
That's what it looks like currently, correct.
So this is current. So it's off of, for lack of a better word, the triangle area.
Correct.
And continues down, but not on the stone wall.
It's not on the stone wall, it's just posts in the grass.
So, but is this the picture that was the issue that was submitted and requested that it be changed?
That was before the cease and desist.
So this is after.
Okay.
Then this is after the
That
cease and
triangle.
desist.
So this is what you want the fence to look like?
That's what we want it to look like.
Okay. So that's
Yep.
what my confusion was. All right, no problem.
Yep. And if you look at the photograph at page 87, you can see where the stake is. That would be the absolute, worst case sight line that I went through. And if you moved it, 3 feet forward, we'd probably have our fence on top of the wall. Probably, we're talking inches here.
So this picture that we have, this is the fence as it currently is right now.
Correct.
And the stake is where it was.
That's the wrong stake. That's an
Okay.
older stake. We were measuring from a different point.
So this stake is the one that's where it's supposed to be?
That's not.
Oh,
where,
that's the
that's
correct-
not
okay,
where it's supposed to be.
correct.
If I can point, I know this is rough for the record,
Mhm.
but the stake is about there. Is where it is.
Okay. So inside.
Do you have the name of the contractor that rebuilt that wall?
His name is John O'Hara. He's sitting right here, and he's the owner of the property.
Okay, because you had what, 3 helpers out there with you?
Maybe at times.
Drive by 3-4 times a day.
Okay.
And the modification to that corner was not pre-existing.
was not pre-existing. That stone wall did not look like that when they started the work.
That's correct. The stone
So
wall
they
was,
modified the corner.
the stone wall was the rubble. It was a rubble rock wall,
They
right?
modified that corner, so the pre-existing fence was not like that.
No, the fence
So you
was.
made a change to a pre-existing fence.
We have not. The fence, yeah, the fence was, the rock wall was changed, but the rock wall is
Well,
not.
the new fence is now on top of the rock wall.
That's right, but the rock wall has no prohibition in the zoning regulations at its current height. Now, if we had built
The
a,
other thing is, there are 6 people who live on that access way. And they have young children who may someday want to drive or whatever. It is a problem for them looking out. The safety of those people is important.
based on what standard?
I want my children to be safe, that's my standard.
Okay, but that's not a specific zoning requirement.
Well, if I understand you correctly, you're saying there isn't a prevailing standard, because the only standard you could come up with refers to state roads or intersections of municipal and state roads. So each municipality has to come up with what they deem to be a reasonable standard, since there isn't a prevailing general standard, if I'm understanding you correctly.
Basically, yes.
So essentially, we're not limited by state standards one way or the other, or the town of Brookfield isn't. And to me, I go up and down that road a lot. The current configuration is far superior to what was there, because it's much safer. There's much more room, and I think for people, and that it's not a state road, but I can tell you, being on that road, people come flying down that road, 40, 50 miles an hour. And I've also noticed, this is a trend in driving, seems to be a recent sport of people coming on the side roads to try to get out before you, even if you're 100 feet away. So, I mean, to me, it seems like it's much ado about nothing, in the sense that why not keep the current configuration, which is much safer overall, whether it meets the specific requirements of the 15-foot eye line or not, which isn't relevant by your account in any case. And in terms of anybody on the road, as Larry was saying, young drivers and people who are coming out quickly, having a little room to see coming out onto a very busy road seems a gain for the minor cost of slight aesthetic variation in the fence. Now, you mentioned fines and other issues. Now, if what this is to do with, the much ado is not nothing, but about the possibility of fines and so forth, that's not a minor consideration, but in terms of the general safety, this current configuration seems to me much preferable.
I mean, at the end of the day, I would say we're here to determine facts as they stand presently and deal with what we have in front of us, as opposed to any forward-thinking ideology. With that being said, do we have the? Are you?
I have nothing else for tonight. I'm happy to continue to answer questions, but
Yeah, by all means.
Mr. Olson, before, when the original fence was there, because I remember seeing that, years ago, did any neighbors express concern about sightlines then? Or was this only after the?
so my client has told me, and
No.
maybe I should just ask him to testify rather than me. So John, can you just stand up and state your name and address for the record and answer?
My name is John O'Hara, 18 West Skinner Road, Brookfield. I've been there since 1994, and no, I've had not complaints before this. And to be honest with you, that fence was there before some of the neighbors even lived there, so it pre-existed. The people, some of the people complained.
I had a question, Mr. Chairman. I realize that you're saying the previous fence was in roughly the same location. Does the current fence meet current setback requirements?
Setback, yes.
Or for an R80 zone?
Yeah, there isn't one that particularly applies. There is no zoning violation for the setback of the fence. That's the easiest way
I
to answer.
realize it wasn't explained as a violation, I'm just
Yeah,
asking.
I don't
if it
believe there,
meets it.
I believe it does.
The fact that he didn't write it up doesn't mean.
Yeah, I
it
believe it
didn't
does.
happen.
I don't think that's an issue at all.
Yeah,
because
I'm asking the question whether you are 50 foot from the property line.
So,
Because I believe that's
no,
R80,
that's,
isn't
that's
it?
not the zoning requirement for fences.
For fences?
Yeah.
Okay,
But also 8-13A would apply there as well,
right.
because a setback is something that's relation to the boundaries of the lot.
Okay.
So the fact that it has existed for more than 3 years
Okay.
would cure any such violation.
That was the only question.
Yeah.
I have a question too. Again, from this picture, are these the mailboxes for all of the, you said there's 6 properties on North, I know you were saying that this is technically not a road, it's a driveway?
It's a
Based on
driveway.
your argument, right? Alright, and are these the mailboxes for,
I see 4, and I see one on the other side of the driveway. Do you know the answer to that?
One of them used to have a PO box. I don't know the exact answer. I do know that the mailboxes are technically in front of my property, not in front of the road.
right, so those, but these mailboxes that are in the picture here, these are the mailboxes for the people that live on this?
One of them's mine.
One of them's yours, and the other
When I
belong
moved
to?
the driveway, I didn't move it right away, so it's still there.
Okay.
Any further questions? Do we have anybody opposing this? Please state your name, address, and your opposition for this.
So first, I didn't make enough copies, so if you guys don't want to share a couple there.
We have a lot of dead trees today.
I'll give, was it Mr. Clemens here? There you go, sir. Mr. Hubert. You guys share this package, sorry about that. Thank you. For the record, my name is Jason Scholler. I'm at 5 Norris Lane in Brookfield, and I have been a resident of Brookfield since 1986. I have lived at 5 Norris Lane since 2008, which would be a total of 18 years. The pictures that I have are probably the Google map that, I'm sorry, what was your last? Olson, that Mr. Olson had provided to you guys. We probably looked at the same pictures and tried to find something. If you look at the first page here, that is where the original fence was in terms of its location. Okay? If you look at the second page, you can see that there's 5 panels there that are on a straight line, and on that second page. You can see that the last panel is turned in. Okay? That right there is well behind that stone wall at that point. Okay? Now, if you turn to the third page, you can see where that fence was. Now, in fairness to Mr. O'Hara, the fence was like this. The last panel was on an angle. In order to rebuild this wall, because it was just all rubble, it looks beautiful now, he had to straighten the panel out. This is the end of the panel. That's where the existing fence was. Just as Mr. Rushmeyer had said, that's where the end of the existing fence was. Now, if you look at that picture, go back one page, please, sir. If you look at that picture, how far can you see? You can see the entrance to Wisconsin. Now, where I'm standing is pretty close to the road, and I'm not 3.5 feet in a car. I'm less than 15 feet away from that road. You can see the entrance to Wisconsin. If you look at the next page, that's what we have.
Thank you.
That's what we have now. Okay?
Can I just ask quick?
Yeah,
So
sure.
You were saying on this, that looks like the original fence, right? On
This is
left?
the original fence. This is where the new panel was, and I don't know if it was exactly as tall, but this is where it went out to where that PVC pipe was. Because that's what you put you're putting posts in there.
Yeah.
So if you look at one of his panels, let me see that
Yes.
picture for a second. That's that panel right there. So the other fence did not come out this far. The other fence was back here on an angle. And you can see it right here. Compare the two. Look at where the wall is. Look at where the angle is. That's the old fence. Here's the angle. That's the old fence. That's all the difference in the world right there.
in terms of line of sight. So again, it went from that to that.
I'm gonna just pull it up on Google Maps, cause it's a little easier. I mean, I know what you're saying, but I remember seeing, that like last one that kinda curves in, I just don't know. Let me just pull it up. Sorry, you can continue, sir. I'm just,
Okay, go ahead, wait.
let's see if this works.
Did the CCA, did they come out and physically review this, or was this just by pictures, or was it done by, like, how did they come to this determination?
I paid them to do a manual survey on our road.
Okay.
And by the way, I'm a chief civil estimator for a company in the middle of the state specializing in DOT roads. Okay, so we deal with line of sight constantly and we're held to a high standard.
This is,
Yep, correct.
that's what it used to look like, right?
Correct.
So-
That angle is not where the stone wall is. That is not the same angle.
So he built the stone wall at some point in the last few years, right back there.
The stone wall's in the
Not-
same place,
not-
that's
not
no
in the
issue.
same place, it's back a little.
It's back a little.
It's back-
on my
it's back about a
property.
foot or
We
two.
Used to put forward a bit more, because it was kind of falling apart in a mess. I brought it center, and everything is back anywhere from 6 inches to a foot. And then the fence is behind that.
But you can see if it's 6 inches or a foot, that fence is a lot farther back than 6 inches. That fence is probably about 15, 20 feet back from the edge of the road, where the old
The
fence was.
wall, not the,
Right, no, I agree. I agree with what Mr. O'Hara said, I'm just saying, this fence is measured about 15 feet back from the edge of the road. Now it is not, now he moved the wall back a little bit, about a foot or two, but he's right on top of the wall now, before he was back here.
Okay.
So that's all the difference in the world to us. Okay, now if you go on to the next picture, this one, this shows in a plan view where exactly he moved this, what fence he actually moved. It was only that 30-foot section, so it's only 3 or 4 panels, but it made all the difference in terms of a line of sight, okay?
Has Brookfield Police Department been out there and done their own individual assessment of it?
They did, they got 220 feet out of it. Sergeant Frank said they do not know how to conduct line of sight surveys to me. He said we just pulled the car up to the edge of the road and we just look and see. I want to keep going through these documents though, if that's okay. I'll keep it quick. The next page, which is this page, gentlemen, is the Brookfield Town Code, which Mr. Olson had gone over with you guys, okay? It just simply says that fences shall not be placed in such a manner as to inhibit the line of sight or otherwise affect traffic safety. And we believe it is affecting traffic safety, okay? This chart here, this Brookfield Town Regulation, this was sent to me by Ralph Tedesco, who's the head of the DPW, okay? And he made me aware, at 25 miles an hour, the town of Brookfield standard is 300 feet. DOT is 280, okay? Now, there's a reason why that's important. As it was mentioned, cars come down that road at 40 to 50 miles an hour. So you can see as you go higher, you need 500 feet. Nobody can achieve 500 feet because Wisconsin ends less than 500 feet later, okay? But that 300 foot is important for you to remember, okay? The CCA letter. CCA does this constantly, every town in the surrounding area abides by the 15-foot mark for a line of sight, the ISD, okay? This one says that the requirement is for 25 miles an hour is 280 feet. They measured the 15 feet back, center line of Norris Lane. They called me immediately and said, we have X. What do they have now with that fence? 58 feet. Why is the 300 foot important? At 25 miles an hour, at 300 feet, that's 8 seconds. 1 1,000, 2 1,000, 3 1,000, 4 1,000, 5 1,000, 6 1,000, 7 1,000, 8 1,000. At 58 feet, you have 1 second, 1 1,000. You have 15 school buses that pass by that road every day, twice a day, with school children. They have 1 second to determine whether we're going to pull out in front of them, and we have 1 second to determine if they're going to come down the hill and hit us. Now, these requirements for DOT only apply to automobiles. With trucks and buses, it gets even more stringent. okay?
What's the average exiting, number of cars that exit that road, Norris Lane, a day?
Anybody know? You have any idea?
Well, there's six houses that are.
There's 5 houses.
5 houses, so-
But there's a 6th house on Wisconsin that exits on Norris Lane, that's Bob Nuzzi. I would say probably, I don't wanna be unreasonable. In and out is 30 a day?
At least,
Is 30 a day?
yeah.
I mean, we're in and out of there, we have 5 people in my family, we're in and out of there once, if not 2-3 times a day.
30 times exiting, 30 times returning.
Yeah, roughly.
And on average, how many accidents have you observed in your years since living there on that street coming out of?
I've never observed any accidents because we never had a problem with the line of sight
How
before.
many have you observed since the '97?
I've observed one.
And
It was one of the neighbors, Bruce, pulling out to his mailbox, and after he got his mail, he backed into the next door neighbor.
Bruce is right there.
okay.
That's as much of an
You
accident.
said you got into an accident?
He backed into Jeff, the guy
You
next to
said you
him.
backed into Jeff.
Oh,
You asked.
All right, so the next 2 documents are very, very important though, okay?
there was a no property damage.
This page right here. This one, okay?
He pulled up behind me and I didn't look in my rearview mirror.
So,
1 second, sir, can I just get?
sure,
That's the,
that's the Ralph Tedesco correspondence.
We got that originally.
Yeah, I asked Mr. Tedesco, I said, the question is, will you accept the CCA line of sight measurements and the attached CCA letter and the attached DOT line of sight measurements 15 feet from the edge of the road and center line of Norris Lane? Mr. Tedesco, head of DPW, said the CCA method is acceptable. In question regarding what is a major and what is a minor road, I asked Mr. Tedesco again in an email. I said, just out of curiosity, what type of road is Wisconsin considered? Is it a major or is it a minor? His answer was, Wisconsin would be considered the major road with Norris Lane the minor. And he's the one that should know. I'm sorry, but not necessarily an attorney. If you look at the ISD, which is the DOT document, and you look at
Do you know what my job is outside of here?
paper management,
Staff attorney.
sorry, well, that didn't help my case.
No, not at all.
Okay. So
well, could I ask, sir, before you
Yeah.
explain, you're talking about the state standards, right? Mr. O'Hara brought up that because it's not a road that would be classified under that it wouldn't apply. How would you respond to that?
I would respond that they're wrong because within here, that it is noted on the DOT documents, minor and major road, right on the diagram. And Mr. Tedesco clarified, Norris Lane is the minor, Wisconsin is the major. That's how I would clarify that.
Right, but you've already said this would be the controlling anyway, right?
That's the controlling distance, but how they measure it
Okay.
is based on,
Oh, major and minor. Okay.
right, exactly. So if you look at the DOT law, DOT code, 11.2, section 4, C contradicts what they told you. ISD from all drives to a single-family residential dwelling unit should meet the full ISD standards. No question. These are the full ISD standards right here. You can see what it says right here. It says minor road, and right here it says major. And Mr. Tedesco cleared that up nicely for us, okay? 15 feet back, that's how you measure the line of sight. That's what we did. CCA does this day in, day out. They designed half of Brookfield. They are in Brookfield, and they know how to conduct these surveys. The police department admitted they don't know how to conduct these surveys at all. They're not certified to do it, nor are they trained to do it. They're just told to drive out and see what they can see. That's
So
it.
how far from the street is this stone wall on the fence?
I haven't done the exact measurements because I've respected John's a man of privacy, so I've respected not going out there with a tape measure and measuring out all of this.
I mean, technically it would be what would you call this? Yeah, I mean, this wouldn't be an invasion of private property to stand on this road and measure from the fence to the road.
Well, We
Well, because
could,
the issue that I'm having is these pictures that you submitted are significantly closer to the wall than the average vehicle would be, especially if it's taking a left turn out of Norris Lane. So it's kind of hard to visualize this being, if you're taking a left out of Norris Lane and you're that close to the wall, then you're going to be in an accident because you're on the wrong side of the road. But if you're approximately this distance away and you're pulling up to see it, I don't see like beyond the mailboxes. I wouldn't know how difficult that would be considerably.
I understand.
Do you understand?
let me see this picture, please. My point is, no matter how close or how far you get, you had no issue when the fence was back there. Now that the fence is over here, measuring it per the code, you have 58 feet, that's it. That's 1 second.
But the police said 280 that they got.
They said 220,
220.
so it still doesn't even meet code.
I'm still having a little trouble like reckoning that because I'm looking at the two panels here on the thing, and I'm trying to figure out if it's truly in the same spot as where he previously, because they claim that the new fence is like in the exact same spot as the old one, and that would make it pre-existing. But if you move it at all, then I think that doesn't apply anymore. So here, that if I'm looking at the same edge, that edge right there is this edge, right? And
That,
then,
no, go back. I'm sorry. That fence was made straight, okay, so
Yes.
that edge was right here, okay?
Yes.
This wall was built, but, I'm sorry, I apologize. The wall got smaller because the rubble spanned out. So now, it's maybe a 2-foot wide wall, so it went from this to this, okay? So that means this fence was where it was, right here. So if you go back to that other view where you're looking at it from the side. Yeah, zoom it, no, perfect, perfect. You can see that it's back from the stone wall right there.
Yeah.
That stone wall is pretty close to the mailboxes. Now, he pulled it back, about a foot. But the new fence, I keep touching the screen, I apologize. The new fence is on top of the wall. And it's only probably a panel of maybe 6-7 feet, but it made all the difference in the world for us to be able to see. I mean, we have, we have 3 people on that road that have cancer. We have 3 people that are over the age of 80 that have to get in and out of it to get to the doctor and medications. That's a big concern.
no, I'm not questioning that at all. And it's more of
That fence you can clearly see, when you look at it from the side, is back from the edge of that wall. If that wall was put where that rubble is, the new panel sits on top of it.
Okay, I got you. Even though this is just rubble and then it turned and they made it into this actual thing.
Correct.
Okay.
So now, if the rubble's here, he's putting a fence panel all the way to the end of the rubble. Within a foot or two, okay? So, this picture is where the panel is, or was, until Mr. Harrow took the fence down. All we're asking is that he just keep it in line with this. I don't care how he does it, but it's only this 30-foot section, which is 4 panels.
So that's a modification of pre-existing fence.
Yes, and that's what he has seen out there and can attest to. Okay? And that's what we're asking. If you look at the last page, just skipped through everything. If you look at the last page of what we're asking for, all we're asking for is him to keep it in the current state. That's it. We're not, now, if you look at the DOT code and what Ralph Tedesco is willing to accept, that last picture, sir, that, the longest part of the fence still remains. And we don't have the original line of sight. But we want to work with John because I believe he's got a right to his privacy. I don't think he should have to take that fence down. And I have agreed with Bruce, and I've talked to some of the other neighbors who didn't want to keep quiet about it. They all agree that they have enough line of sight to work with John if the fence stays in this location for that 30-foot section.
Even if it's not curved in a little bit.
Even, exactly like that.
Right.
Where the original fence was.
But I thought the original fence would have gone like this.
He can put it back on an angle. That'd be great.
But that would, because then that would be the exact original, and then they would have a leg to stand on with that, being that it's in the exact spot of the original. I know that it doesn't make sense with the rock wall, but he could probably move that.
You know how this all gets rectified? He has to have an engineer take a look at the line of sight and tell him exactly where he can put the fence. That's how design is typically done with a line of sight issue. And it's got to be approved by the town. So if a zoning application had been submitted, you guys would have probably caught that and would have said, hey, what's the line of sight at this point? And then they would have been able to survey it, and then he would have known exactly where he could have put that fence. If he leaves this fence right here like this, it all goes away. School buses can see us and we can see them.
But if he puts it back to where he had the original fence, you know, in the same exact spot,
In here,
not there, not there. I'm sorry, you're saying that this is, I know this is where the
This
new
is the
one
new.
is. Yeah.
this is the old, because you can see how old the fence is.
No, yeah, yeah. But if you put it back to exactly as the exact spot of this old one, exactly like this.
Yep, if he put it back and the line of sight was right in line with this joint right here, we would be fine with that.
Okay.
But he doesn't get it would be right here. This coincides with this.
Yes.
We would be fine with that.
Okay.
Okay? The only problem is I understand what he means though, it's ugly. Okay? You're gonna have a wall and then a fence. I get that.
Yeah.
But if a zoning application had been applied for, this would all got worked out before the fence had gone up. Okay?
I don't think you would have.
Yeah, I don't think you would have needed a Japanese zoning application. It's
Well,
a,
we're here now.
Yeah.
over
For
here,
a different reason.
yeah, not because of the zoning application.
But he would have needed it for line of sight though, correct?
I don't think so.
No?
No.
What is incorrect, fences are not regulated with the exception of when it becomes a problem with line of sight and various other things.
Yeah.
I believe it was the regulation that attorney,
It's in excess of 8 feet tall when you add in the wall.
in excess of 8 feet tall.
When you
Well,
add in the wall.
in certain locations. In this location, yes. In other locations, no.
Yeah.
Other
So,
locations, it's less.
Depending on the actual height of the fence in all locations, and I have not measured the fence myself, if it is over 8 feet tall, it would require a building permit and also a zoning permit.
I think it's 7.
There are portions of the fence that are-
Well, if it's on a hill, they have to take into account from the ground to the top of the fence, not from the angle that used to be on the
No,
hill.
I think he measured from the wall up to the fence.
But if the wall is separate from the fence.
It's combined.
Okay.
And it's 7 feet, I believe.
It was still within that 8-foot threshold.
But it shouldn't go past this because that's the existing location.
So that was the thing that I wasn't realizing at the initial part. This little box right here
That little box
is the
is
additional forward.
right,
Gotcha.
exactly,
I got you.
exactly. So I don't know if John will talk to you.
No, but it's.
I just want to make sure I'm telling you the truth.
No, yes,
Right?
absolutely.
John, I just have one quick question. John, you took down both panels, correct? I think you did, right? Because I don't think this is
Everything should be
behind you. I'm
descriptive.
just trying to speak.
So which one is, you guys, you can direct all comments to me and
Sorry.
I can then pass on anything that needs to be addressed elsewise.
Well, the basic point that he's making is that, you know, it looks like it's the same thing. It's really not. This is the ideal scenario would be this rhombus
That
is
panel
here.
and the line that goes with it
Yes.
to the edge of the driveway, which is 4 panels, is back in line with this. That's
Move it back.
that's
2 or 3 feet or however much that is.
That's probably about 6 feet right there. But it's to where and that angle's very distinct.
I got
You can see right here where the angle is.
Yes. Yes.
You can see this angle, and this is the old fence.
Yes.
I mean, it's pretty simple.
Makes sense. So it's not in the original place, but
It's not.
as they claim.
No.
Okay.
But I don't want to make him take down the rest of the fence. I mean, I don't want people telling me, I don't want to tell him. But when my kid can't get out to make a left turn to go to Brookfield High, and she almost gets T-boned by a bus, if she gets hit by a bus, kids get hurt, then what, the town's got now a big problem on their hands, you know?
Of course.
Just to add a comment about the streets, you know, at least as I understand it, 25 is a state road. Stony Hill is a state road. So Wisconsin joins 2 state roads. And because I live on Stony Hill, I know what the traffic is like. And most people, as a way to get to 84, go up Wisconsin and take 25. So it functions effectively as a major commuting route. And people drive it rapidly and there's tons of traffic. In fact, I have a hard time getting out of my driveway on Stony Hill. And all that traffic goes up Wisconsin. And I can sit there sometimes for 5 minutes before pulling out. So to me, it's a big safety issue. I mean, that trumps anything else in my mind in this whole discussion. And I think the line of sight issue is clear that with traffic coming down or going up Wisconsin, you need you need visual space to see cars coming or from either side, so.
Right, I agree.
That is, I think, the primary concern to me.
Mr. Clemens, I typically mow this area, I weed whack it, even though I live way down the road, I come out and I take care of the mailboxes and stuff. I put out a cone right here, so that way people move over a little bit. Twice that cone has been hit and it's flung into me, and people fly by me like it's nothing. I asked the police who were running radar out of here one day, I said, what's the top speed you've ever caught somebody? They said, we've caught like 3 people between 60 to 70 miles an hour. Now, that's not Mr. O'Hara's problem, okay?
They got that little radar down the street right next to the church.
Yeah, going up the hill though.
Yeah.
Why they won't put one going down the hill, I have no idea, because it's a 25 mile an hour, this is a school zone.
Yeah, I live on Wisconsin. I'm pretty. I live actually right directly across from this intersection, so I understand the concerns. On the other side, yeah, I live on the Wisconsin side.
Maybe do you live on the corner in the yellow house?
No, I live a little bit further down. Well, a lot further down. Like I'm like the second house into Brookfield once you're coming up 25. So, yeah, I frequent that to get to Brookfield like to get into like the
Right.
downtown area.
Right. I mean, shoveling or anything's dangerous out there. I mean, I'm constantly jumping out of the way of cars. So.
Yeah, there's a lot going on here.
It's one panel. It's 6 feet, makes all the difference in the world to us.
Are you done with your part? Do you have is there anybody else that needs to?
I think I am. I think, the conditions that we have on the last page stand. I mean, but whatever's decided on, I think there should be an A2 survey done and submitted to zoning so it's on record what's all been agreed to by the board. And that way, any future owners of that property won't be able to move it. And you won't have this issue again. Okay.
Thank you.
You had a question over there?
No, I think he's coming up to again.
This,
Yeah, I'm Bruce
Thank you.
Benasek, I
Thank
live
you,
at
sir.
4 Norris Lane. And as of today, I have no problem with the fence as it exists. The old fence I had no problem with. When the fence extended its full depth towards West Wisconsin, I had to encroach on the roadway. I had to stick my car nose out into the traffic lane in order to make a left-hand turn. And it was just plain dangerous. As it sits today, I'm fine. Leave the fence as it is.
Any further comments for application for 18 West Wisconsin Road?
Mr. Chairman, could we have Attorney Olson come back up?
Sure.
I was planning on doing that.
Okay. Come on up.
Scribbling furiously. But was there any other members of the public who wanted to speak?
No, I think they. Anybody? No, you're okay. It's all yours.
I have a few sort of rebuttal points. They're going to be kind of all over the place. So Ralph Tedesco's comments that West Wisconsin Road is the major road and Norris Lane is the minor road, I think I agree with, in the context of how do you apply the highway design manual and which section applies. So if you look at the section that we've been talking about, that's correct. But Ralph wasn't saying that West Wisconsin Road is a major road and Norris Lane is a minor road. Those are definitions in the highway design manual that apply to situations where the highway design manual applies. So I would argue that trying to apply the standard, that's how we would consider them, but that's not what they are. Norris Lane is a common driveway, period. The manual, the highway design manual, is intended for construction projects. That is, things that are being built. It does not apply to things that have existed for many years. So we're not going to take an existing sightline condition and try to apply the highway design manual requirements over the top of that. Right? The sightline is what it is. You can see as far as you can see. And whether it meets the manual or not is not really relevant to anything we're talking about here today. The only question, I mention that because we've talked a lot about how many feet you should be able to see and what was measured. The only question is the sightline that exists obstructed by the fence, which is a yes/no question, not a how much and how little. So the picture that was submitted by Mr. Scholler, that's at page 87, shows a stake along the wall. That stake was placed by a licensed land surveyor. We don't need an engineer, we had a surveyor come out and do that. And the big question that he and I talked about is, where do we measure? Again, this is the 15-foot question. And when we placed that stake, what we measured was 15 feet from the edge of the pavement. Now, you'll remember I said I don't think that's really the right place to measure from. We should be measuring 15 feet from a point that's quite a bit closer to, say, the center line of the road, because the road curves in, there's a curb and a catch basin, right? That's how you find out what is the travel way, which is what the manual says you should measure your 15 feet from. Now, I asked Mr. Tedesco where the travel way was, and he was spectacularly unhelpful. He refused to give me any guidance as to what I could consider to be the travel way in the town of Brookfield's opinion. So I'm left arguing to you that what you should say is the travel way is the edge of the catch basin, is where you measure the travel way from. And if we did that, and we took 15 feet back from that, we're probably going to have a stake that's about 3 feet closer to the front, to the road, to the front of the wall. And honestly, if we did that, the fence probably can go right up against the wall. Right, we can see exactly where that point is. And if that were acceptable to the zoning enforcement officer, then we could put the fence back in that location. And, you know, we'd be able to say we're complying with the highway design manual, which we don't think applies, but we're gonna comply with it anyway. I don't see any way that anybody could argue that if you're in compliance with the highway design manual, that it's still unsafe. I think if you're going to say the highway design manual is the appropriate standard, and then we comply with it, the next step has to be that we're safe. If it's not, then we're back to the point I originally made to you, which is this zoning regulation is too vague to be applied. Because nobody has any idea how you're supposed to measure this, and how you have any idea how you're supposed to know if you're in compliance with it.
Mr. Olson?
Yeah.
So, can I just look at this with you for a second? This is 2022, the original fence, right? This is the new fence as it looked, and then you moved it in, and that it's, you know, it's on a right angle. Is this line here, where the last section of fence curves in, is that line this or this?
I believe it is this.
Okay, so if it's that, then that means the angle on this, the actual curved fence is definitely not in the same exact spot as the last one. And would there be an issue if Mr. O'Hara had to move back, basically take this exact piece and just take out this little rectangle here and move it back a few feet so that it's truly in the same exact spot as the original? Because then I think that would give more legitimacy to the argument about it being pre-existing non-conforming.
So
And move, I understand, you know, the
you're asking a difficult question, which is actually my final point here, which is it's not this board's job to reach agreements. Like Mr. Scholler said, well, we should submit an A2 survey to represent the agreement that we've all reached here today. It's not your job. You're not here to broker an agreement between anybody. The only question you have before you is, did the cease and desist order comply with the zoning regulations? And I presented several arguments. As a legal matter, it's defective because it listed the wrong address as to where the violation was. So that should be number one. Then number two, 8-13A should apply. Number three, the regulation's vague. All of those have nothing to do with the actual facts on the ground. Step two, if you did that, would be we want to put the fence back up, and I've had a number of conversations with Fran Lally, the zoning enforcement officer, and I would speak with him about what is acceptable to him, and maybe that's something that's acceptable to him and to my client. But I don't think you should be in a position here tonight where you're negotiating what the ultimate result is. Because, to be blunt, that's not your job.
Yeah, we have three options.
It's not your job to do that, not your job to impose requirements like making a
That's
submitted
not our
A2 survey.
We have three options.
Yeah.
Uphold, reject, uphold with stipulations. Or reject with stipulations. We have four options technically. But our job is not to act as intermediary between parties. Our job is to validly determine if this is a correct cease and desist. are valid. Your facial argument about errors, since it's not a court order, or it's not a subpoena, it's not a judicial document, any errors or facial mistakes are not something that would make it invalid or determine its invalid or validation, as it's not signed by a judge, so it doesn't hold or have those same standards as generally applicable documents.
Except cease and desist orders are essentially important documents
Yeah, they're
to that
important,
extent.
100%.
Like,
If
for example, it could be referred to a state's attorney based on it.
yeah, but
We have rights that are waived if we do not appeal them.
and you appealed it, and you're upholding the level of appeal, but the document can't be invalidated for errors that are not significantly prejudicing your client. Did he get the cease and desist letter to his house? Cease and desist letter to his house? Did he have the opportunity to respond to the cease and desist letter? Did he have the opportunity to review and make any recommendations or requests for hearing? Obviously, he did. So.
He had no choice but to appeal because he waives any right to claim that he was not in violation if he doesn't appeal. But nevertheless, it is a defect. It says there is a violation on 40 Hidden Brook Road, not 18
understand.
West Virginia. So
Noted.
I respectfully disagree with your interpretation of the law on this point.
Noted. Do we have any other comments?
Can I just make one comment?
Sure, you can come back up and restate your name for the record.
The Connecticut DOT law states about minor roads, and it's in your package. It says typically assumed to be 15 feet from the edge of the major road. Wisconsin is a major road. It's from the edge, not the center lane, not the center of the road. It's from the edge of the road. So even though they don't agree with it, they're saying they comply with and had a surveyor comply with the DOT regulations. DOT regulations are clear. 15 feet from the edge of the road. CCA agrees, DOT agrees, Ralph Tedesco agrees. So the 58-foot mark of line of sight, 1 second, applies in this case.
But as noted, the DOT regulations go into building, renovating, and planning highways. It's not a metric or standard for existing roads and highways that are being observed for the purpose of what we're doing right here.
I believe it's also for modifications as well.
For the roads, not for like the fence, which is what we're dealing with here.
But I believe it also includes from the design manual, 1 second please.
Design.
It talks about existing structures too, that no code can be routed around that.
I appreciate it. Is there any other information in regard to this specific ZBA 26-8, 18 West Virginia Road? If not, I will close the public. Oh, you have the opportunity. Do you want to state that as your last, or do you want to?
I'll just make one last comment to follow up on what the chair just said, which is the town of Brookfield has not adopted the highway manual as law applicable in the town of Brookfield. It is free to do so. Many towns have.
I have a question specifically to that. What is the standard?
There is no standard.
I mean, you're arguing there's no standard.
There is
so
no
you're
standard.
saying under that interpretation, you can build a fence right up to the edge of the road.
Well, this is the problem.
I mean, basically, that's what you're saying.
This is the problem.
I agree that legally, that the state standards don't necessarily apply. But I'm going to make I'm going to say if the town, if the zoning enforcement officer decides to go measure this and measure 15 feet using the state standard, major, minor, and also the speeds and the 300 feet that are in the Brookfield regulations, then that would be the standard that should apply.
So, lawyers' jobs are to find problems with the regulatory framework and point them out.
I
right?
get it,
So,
I get it.
So let me just follow this line through. That, to me, there's a significant problem with the regulatory framework.
Right,
That you say, don't obstruct the sight line,
right.
but you don't say how to determine if you're
It's not objective.
if you're obstructing. the
It's
sight line.
subjective, it's a
It's a
subjective.
very subjective standard.
Right.
So, if this were the zoning commission,
Right,
Planning and Zoning Commission now, and you were reviewing an application for a site plan, there would be a back and forth as to, you know, what the,
Right.
what's supposed to be. But here we're talking about, have I violated the zoning regulations?
Right.
And I don't know. I can't tell you because we don't have particular enough information.
Right.
So what should happen, you should amend your regulations to say, sightline means a distance that's 15 feet from the edge of the,
Or use the
Pavement,
state, or use the state
or
standard for.
whatever the state
Right.
highway design, right?
Right.
Put that in your zoning regulations. Highly recommend that. I see
But in the
Laura
absence of that,
nodding her
we
head,
have to
and
work,
maybe she'll do that.
we have to work
Right.
with something.
No, I think the point is that in the absence of that standard in some contexts,
We have to be reasonable in the application.
you are reasonable. In other contexts, you have to recognize that you have no
Right.
standard. But you'll recall that my argument to you was you should apply a reasonable standard, and that reasonable standard could be 15 feet from the edge of the travelway.
So then your argument may be, maybe if the cease and disorder, a cease and desist order is negated, for lack of a better word, that a sightline agreement could be made with the homeowner on measuring this between that and the zoning enforcement officer?
Between the
Is that-
homeowner meeting my client,
Correct,
and the zoning enforcement officer meeting
Correct.
Fran Lawley, before we put the fence back up,
correct.
I will be discussing with Fran when he gets back from his surgery.
Yeah, should that be the decision of the board?
Because I don't want to put a fence up and have Fran issue another cease and
Right.
desist and have us right back here arguing.
Exactly.
So-
But with the lack of an objective standard, you're saying it's hard for the homeowner to have to pay penalties for something that's that big.
Correct. I'm saying-
Okay, no, that's
yeah.
it, that's okay.
But just to be clear, I could say to Fran, we're gonna put the fence up in this location, and here's why, it's 15 feet from this. Are you okay with that? And Fran
Right.
says yes, and we put the fence up, and then a complaint is filed saying it violates the setback, and Fran doesn't take an action, and that lack of action is
I get
appealed to this board, and we're back, right? I can't guarantee that, but
Right.
look, that's how
But I'm
this,
saying that's, as
Yeah,
far as
it-
a reasonable
we
approach
can't
to a
im-
standard,
yeah. We
that
can't
may-
impose conditions and any of that, because again, this is a simple question, but that's my intention as to how this should
Thank you.
proceed. I'm not gonna let John just go throw it right back up where it was when you
I
reverse
think there's
Fran's order.
something that's getting a little misstated here, because in the absence of the state standard as reigning in the case of a municipality, the municipality then has discretion. It can make its own standard.
right,
And when the zoning officer makes a judgment, that's the town making its own established decision and definition. So other standards don't apply. I mean, whether it's the state or anywhere else, because Brookfield, as represented by Fran or whoever the zoning officer was at the time, made a decision based on information gathered, and that was the standard used. I mean, it's a reasonable standard. We might disagree with it. You know, some people might say, well, the sideline should be less than 15 feet. It should be measured from the center of the road, not from the side of the road. There could be lots of disagreement, but the decision made was reasonable, and I don't see that there's a reason to question it given that, and given the fact that there isn't a state standard to which we have to hew in applying in this case. To reject the current cease and desist order, you'd be going through the same merry-go-round again, because you'd be back with Fran making a determination.
Did
right?
Fran have opportunity
So,
to like
whoever it
physically
was.
observe this and like see and go to the property and do all this measurement?
I can speak to that,
All right.
absolutely, I was actually with.
Before you do, can I respond to one point here? I'm sorry.
Yeah.
I was with you most of the way.
Okay,
To me, the town has the authority to adopt a standard,
right.
but that should be adopted by either the Planning and Zoning Commission as a zoning regulation, or the Board of Selectmen and, I guess, the town as an ordinance of the town. That it should not be a case-by-case basis of the zoning
I
enforcement
agree with that,
officer.
yeah. I don't disagree with that, but I think in
Sorry.
the absence of that, you have to make decisions, and particularly when it comes to, for me, issues of safety. I mean, to say we let something go because we don't have a standard, even if it creates an unsafe condition, does not make sense.
All
Can I
right,
just have, can I ask one question? How many notices were sent? Does anybody know?
three,
I believe there were 2 notices of violation and 1 cease and desist order.
and then the town attorney's letter too, right?
That was also town attorney's letter, which is the third one that I was having.
So it's-
Before we close the deliberations, or the public portion, do you mind attesting to what Fran had to say about the situation?
Absolutely, I was on the site as well with Fran when we did do the measurements from 15 feet. This is the first time, once we did receive a complaint that the fence was constructed in a different location or possibly a different location that is blocking the sightline. My concerns also are, I know we're being given the representation that the fence was totally kind of constructed in the same location. Is there an existing survey of the fence or a pre-existing survey of the fence that shows the actual location of the fence? We're going off of recollection, photos. A foot, as we know in this particular case, does make a lot of difference. I can definitely understand and speak to Attorney Olson's point that there was an improper address that was put on that cease and desist order. Unfortunately, those things do happen. We do process a lot of applications. To clean it up procedurally, I would actually recommend that he reissues the cease and desist order with the proper address, and that kind of closes that loophole there. Just for cleaner, because it does get brought to court. But no, measurements were made. We did speak with the town engineer. You've heard Ralph Tedesco's name brought up several times this evening. He is a licensed engineer in addition to the director of public works. He did weigh in that there was a concern on the sightline. In addition to our police department that did weigh in that there was an issue on the sightline, and a private engineering firm that has attested to the fact that there is a concern of the sightline. So whether or not this board views it as the cease and desist was issued improperly, that is entirely up to the board. My recommendation as the land use director to our zoning enforcement officer would be to reissue the cease and desist order to clear that up. But as it stands, there would be no need to reissue the cease and desist order because I do not, and Fran does not find the current location of the fence to be in violation of the zoning regulations. So in some ways, it almost feels a little bit moot.
Yeah, as it stands today,
As
like
it
with the
stands
panels
today,
removed
with
and.
the panels being removed.
Okay.
So if something was going to be constructed, it's very interesting hearing that the fence might or might not be 8 feet. Thereby trigger a possibility, but that is not for this board to consider. That would be up to the building department on whether or not they found a building permit necessary to build it, and also on whether or not it triggers any kind of zoning regulations. But that, again, is a different matter.
Have any fines or penalties been
No
levied?
fines have been issued to date on this. There have been no citations, no fines. It was just simply an issuance of a cease and desist order, and the applicant has exercised his ability to appeal.
All right, with that being said, I'm going to close the public portion of this specific case, 26-818 West Kinnear Road. What that means for you is that this is a wall. We will be speaking amongst the seated members who are Dick, Liam, myself, Elijah, and Terrence. There is no need to sit any alternates as we are fully staffed board. And any communications that we make amongst ourselves are as if you are not there. We may come to a decision at the end of this, we may not. As you know, for this to be moved in any direction must be 4 affirmative votes. And we'll move into our closed deliberations.
Do we do it tomorrow doing after?
Oh, to do it after?
Yeah.
Okay, so we'll, actually, my apologies. We're gonna go move forward to the next applicant, ZBA 26-968 South Lake Shore Drive. Please come forward, state your name, your address, and your request.
Sure, Mark Davis, Mark and Christine Davis, we're at 68 South Lake Shore Drive. Here in Brookfield, we've been here for about 1.5 years. We love Brookfield, for the record, we are from New Jersey, so.
Don't hold it against us.
Don't hold it against us, but we do love it here. So what we're trying to do, we're ZBA 26-9. So what we're trying to do is construct a 2-car garage on South Lake Shore Drive. It's a very, very tight lot. We're in an R7 zoning. We think that, we need the space to actually get a 2-car garage in there. We are trying to get access from the street, so we'll have some place to get our cars. This really kind of gets a little dicey for us in the winter when it's icy and cold, because we live there all year long. We have, originally we looked at it, it was about an 8-foot variance. However, our eaves on our house are about 2 foot, so that pushes us out another 2 foot, so we wanted to make sure that we considered that. So we're actually requesting an 8, but it was supposed to be 6, it's 8, and I know that that's getting pretty hard. So we talked